And now I would like to introduce Rebecca Goldfarb, estate planning and elder law attorney of Goldfarb and Liu. But Ms. Goldfarb co-founded Goldfarb and Liu on the principle that quality estate plans should be accessible to everyone. Having been the caregiver for 7 people in her family, including her grandfather who had Alzheimer's, elder law is really dear to her heart. She treats each client as family, and she helps each family navigate the aging process. So thank you so much, Rebecca, for joining us today. I know we always appreciate having you here to really break down this big topic and make it accessible and understandable for all of us. So welcome.
So hi, everybody. As Tori said, I'm Rebecca, and thank you so much to every single person at ALZHEIME'S LA. You know, this topic is dear to my heart. As Tori said, my grandpa had Alzheimer's. I always get choked up when I talk about it, and he died in 1992, so it's been a while. So as the only grandchild in my family, I've cared for so many people. And as an elder law attorney, I've helped navigate this with countless clients, hundreds of clients. So I'm here to answer any questions that come up. And let's get started because I have so much to talk about. So next. So today you for sure will learn at least one new thing. That's my goal in all of my presentations. And I changed this a little bit because I feel like a lot of people have estate plans, but they don't realize what these fatal flaws are that we see all the time. And so my goal is to highlight some of those today to give you a better education and also go over estate planning 101. I'm also going to talk about elder law and kind of what comes up, and then have some action item checklists and always be a resource for you. Next. So as you learn every time you get on an airplane, even though with COVID, so many of us haven't flown in a while, is to put on your own oxygen mask first. As caregivers, you know, we're always thinking of everyone else first, but first we have to think of ourselves. Next. So the purpose of an estate plan is sort of 3 things, in my opinion. One is we need to make sure we honor your wishes. So we have to know what they are and they have to be memorialized. The second is at all costs, we need to avoid court if we can. It's a very invasive, expensive, horrible process. And thankfully, my law partner and best friend in Liu is the one who goes to court. I don't do that. And last but not least, and certainly probably from a legacy perspective, the most important is we want to maintain family harmony. Next. Unfortunately, about 99% of the estate plans we review, whether they're attorney drafted or, you know, done in a do-it-yourself fashion, have a fatal flaw the client doesn't usually know about in one of these 3 areas or more. Next. So what is an estate plan? It is comprised of many different documents, but there are 4 main ones. The first one is the Advanced Healthcare Directive. This is where someone can make medical decisions for you. Most people think, oh, well, my spouse can do it, or I can do it for my young adult child, or I can do it for my aging parent. But unfortunately, without this advanced directive, you're not allowed to. It doesn't mean sometimes doctors and hospitals won't turn a blind eye to this, but legally they're not supposed to. And then you also want to make sure you have a HIPAA waiver that goes with it. In our firm, it's a separate document, but often it's within the advanced directive. That's the Privacy Act. And without that, doctors and the medical community could be charged big fines. I don't know that they ever are, but of course, I just know the legal side of it. And then the power of attorney is for everything else. So bills, taxes, you know, the dealing with a CPA and financial institutions, credit cards, everything else. So once you turn 18, you need those documents. And then a trust and a will is what happens to your stuff, essentially. So if you have kids, you have assets, you know, you don't want it to go through probate, and all wills go through probate. So a trust is very important. Probate in California is horrible, which I'll talk about a little later. Next. So remember, if you're over 18, you need these advanced directives and powers of attorney. Once you lose capacity, you cannot create them. So it's important to do it well before that happens. Next. And again, if you have assets or kids, I'm used to being able to hit the next slide. So these ideas that the myth that's out there is that if I have a family, everything will just kind of happen automatically, and it doesn't work that way. So I have two polling questions. How many people have an estate plan, and have you updated it in the last 3 to 5 years? So I don't know how you do that poll. So the problem is twofold for people. One, people don't have a plan when needed, and two, it doesn't work when needed. Next. And these are examples of the fatal flaws we see. So we either have outdated documents, laws have changed, people have changed, wishes have changed, assets have changed in the trust. And then we have missing documents. We see, I kind of laid out some of the important documents, but there are other ones. And when some are missing, then the whole plan doesn't work. Sometimes documents are so confusing, especially if someone has made several amendments and they can contradict each other and make trust administration really messy. And then probably the most common thing we see is trusts are not funded. So remember, you have a trust, it's a bunch of pieces of paper stapled together. And if you don't transfer your assets into the trust, meaning if you have a home, the deed says the trust owns it with you as trustee, or your bank account has the trust on it as the owner in that faceplate when you open the mail, then your trust is not funded. So it doesn't matter what the trust says. The trust can say my house goes to my kids equally, or this bank account goes to my dear friend. That's irrelevant if the trust isn't funded. Remember, the trustee, the person who manages it, has authority over what's in it. But if assets are not in it, the trustee doesn't have that authority. Sometimes we see the wrong people are selected. Either they're doing bad things they shouldn't do, or they're just not competent to do it, or they've passed away. I have a client right now, and she's the trustee, she's 91 and doing great. But then the next 2 trustees are dead, and the one after that is also 90 and probably not willing to do it. So we want to make sure we update these documents as we age. And then lastly, a lot of people try to do this on your own. There's lots of things you can do on your own. Estate planning should not be one of them. Next. So the solution to all that is to find the right law firm. You want to be educated and empowered. Tori talked about that earlier. And we collaborate with you. You want a lawyer who's really going to work with you as a team to create these documents that work. And I think a lifelong relationship is really important. So your lawyer gets to know, you and your family and your wishes for you when needed. This shouldn't be a transactional type of law where you just get the documents and that's it. Next. So what if you become incapacitated, meaning mentally you can't make decisions anymore? Next. In the advanced directive, we go through a lot of details. I don't have time to talk about those today, but the advanced directive fatal flaws that we often see are the wrong agents, meaning these people don't put themselves aside to honor your wishes, or they aren't really equipped to deal with the medical community. It's not easy when you're not in it to understand a lot of the procedures and the diagnosis, and you need someone who will really advocate for you. And I think, having someone local is ideal, but if not, that person can stop what they're doing and come and be with you. So it's not about, it's your oldest kid or something like that. It's really, you got to pick someone who's good at this job. If you have multiple people in place where you want co-agents, it's okay, but the document really needs to say, if there's a disagreement, how is it resolved? We don't want anything like that going to court. And even though they have ethics committees within hospitals, we don't even want to go that route. Springing powers. This is really important. It's also in the power of attorney, so I'll mention it there as well. A lot of documents say, yes, you have authority to make these decisions for me as long as doctors deem me incapacitated. And I know we have a couple doctors on the panel for later. I am having a very hard time, and it doesn't matter if you're at Kaiser, UCLA, Cedar, it doesn't matter where you are. I'm having trouble getting doctors to want to get involved in deeming people incapacitated. So we bypass that and we just say it's immediate. When you sign the document, it's immediately effective, so you don't have to go through those hoops. Sometimes we can't get people to go to the doctor, so we just can't get it done, and it causes a lot of trouble. We see a lot of advanced directives missing the HIPAA or the California CMIA version. This is the Federal and State Privacy Act. We want to make sure all of them have that. And I would say the most common thing, and I would say it's in 100% of the documents we see, there are no details. So here you are saying, please, so-and-so, make these medical decisions for me, but I'm going to tell you like one or two things. I don't want to live forever. Okay, well, that's not enough detail. We need detail, people. This is a huge burden to put on someone without all those details. And then lastly, there's something called a POLST, which is the physician's orders for life-sustaining treatment. This is it replaced the DNR, the do not resuscitate. So toward the end of your life, when you don't want to be resuscitated, it's critically important to have a POLST. And I think I have a slide about that in a bit. Next. So the durable power of attorney means that someone can make legal and financial decisions for you if you become incapacitated. Again, we see the wrong people in place. You should not have two co-agents. Financial institutions increasingly are not accepting powers of attorney with two agents. And then if there's a disagreement, it must resolve it. And I've never seen one that does. So I would just say you need to pick one person and then the next. It can't be someone who is kind of strapped financially. It should be someone who's really good with finance and is not a procrastinator. I had someone who was a power of attorney who didn't open mail for a year or so, right? You got to be on top of this stuff. Again, springing, same thing. You want to make sure they're immediately effective. But with this one, I say, don't give this document out. And if I had more time, I would talk about it. But with the advanced directive, give it out. You need it in an emergency, urgent situation. With the power of attorney, you don't need it urgently. So keep that with your documents. I always tell people, I want to know if something's happened to one of our clients, but have your next in line call us and we'll decide when the appropriate time is to hand that out. So there is something called gifting, and it is a legal term of art. It means that if you are incapacitated, can your power of attorney give money to someone else? You may not see it as a gift, but it is legally a gift. So we want to make sure that there is the authority to gift. There are limitations on that when appropriate. And in California, if you do not have that specific language about gifting, the presumption is no gifting. So with Medi-Cal planning, this becomes very tricky because we can't spend down, even though those limits have gone up. We still need to do that sometimes. And then just as a practical matter, I'm a lawyer, but I'm also just a normal, regular person. And I live in reality, as do all of you. So it's important from a reality perspective to have all your logins and passwords and bills handy, written down, because if you don't have that, you can't get into these accounts and it makes it really difficult. Remember, each financial institution has their own power of attorney. So you will take the power of attorney, that the attorney creates, you will take it to the bank and then you will fill out one for each institution. They will need to send this to their legal department. It can take 2 weeks, 3 weeks. It's kind of a pain in the butt. I realize. I wish I could change it so this wasn't the case, but I can't. So just be prepared for that. Next. So what happens if you pass away? This slide, I use it for a long time in my memory club presentations and other ones. And then finally, I saw all those weapons behind their backs. And so that made me kind of chuckle. And you think it doesn't happen, but boy, does it happen. Maybe not with the weapons, but next. So a lot of people ask, do I need a will? Do I need a trust? I don't know. So remember, all wills go through probate. So if you have less than 184,000, then you don't probably need a trust unless you have a special needs beneficiary or you want to hold on to assets over time. So if you have under 184,000, you're probably good with a will. And how we determine what goes into that bucket to tally up to 184 is assets that don't have beneficiary designations. And so sometimes people think they're beneficiary designations when they're not. So triple, quadruple check that to make sure and keep a copy of that. When these financial institutions merge, sometimes these Benny designations don't get transferred properly. So if you're okay with giving it outright, you don't have minor children, a will might be okay. If you have real estate, you want to sprinkle assets over time. You have kids, grandkids, special needs, all of that. You definitely need a trust. Next. So what is probate? Well, besides the fact that it sucks, it is when you have a will or no will, you have more than 184,500 without beneficiary designations or transfer on death or joint ownership. And then it goes to probate. And probate, they need to have a valid will. If it's invalid, then the law of intestacy is going to take over. This dictates your next of kin in a particular order. And if you want special people, a longtime partner, let's say, to get something, it's not going to happen. You want special, nieces and nephews to get certain things, or friends, not going to happen. It just goes by next of kin. So it could be your distant cousin you don't even know who gets everything more than your beloved partner you've had for 20 years. Not the case when you're married, but if you're not married. And then you need to have an executor to be named as the administrator. You have to get a bond, which is an insurance product. So if you can't get a bond as the person named in a will, it won't happen and it'll be somebody else. It's super expensive, a complete waste of money. I'll talk about that in a minute. Assets are frozen for months and months and months. Our whole process takes a year or two if it's not litigated. If it's litigated, it can take longer than that. And all creditors get notified. So it's a very public process, unlike a trust, which is trust administration, which is private. Next. So this is just a typical chart. These are the fees. So go down column 1 and kind of pick what your overall gross estate is. You do not get to subtract a mortgage. If you have a mortgage, this is just fair market value of your real estate. Go over to column 2, and then you'll see what the statutory fees are. This is the minimum. This is just established by law. Lawyers also can charge extraordinary fees for extra things in a probate. The lawyer gets half of those fees. The administrator gets the other half. It's super expensive. As I said, a total waste of money. It keeps going up. It's about 3 to 4% of your gross estate, and you can completely avoid that if you have a trust. Next. So how to avoid it is, like I said, having a trust. We want to make sure that you have selected the right people to be trustees. We want to make sure it's well written and clear. We don't want 10 different lawyers giving 10 different opinions of what's going to happen or what it says. We want to make sure that you have funded your trust. Your assets are transferred from your name to the trust name. And this is how we get to control from the grave. I know, Heather mentioned earlier about how much you guys have raised already. So you are awesome. Big congratulations. Anyone else, if you feel like this is dear to your heart, and I feel like every single person in your living room, usually pre-pandemic in this room, knows how important Alzheimer's LA is, that you can put this in your trust. You can even put it in a will. You can make this, you can make Alzheimer's LA be a partial beneficiary or full beneficiary of an IRA or a retirement account. This is really good planning because your family is going to have to pay tax on that. But a charity, a nonprofit, does not pay tax. So it's a great vehicle. So reach out to Stephen if you have any questions about it. I can't thank Alzheimer's LA enough. I'm going to cry when we talk about it. All of our clients who come from these memory groups are they're just in such a better place than with my grandpa, you know, all those decades ago when Alzheimer's LA didn't exist. So, okay, I'll stop talking about it before I cry. Next. So an easy peasy, as my daughter would say, lemon squeezy trust administration is where you've got a great trustee lined up, your assets are clear, we pay the debts, we pay the taxes, you do the distribution, and then we have family harmony, right? That's the way it should be. Unfortunately, the getting blood from a stone version is where the trustee is the wrong person, and then the assets are not in the trust. And so have to go to court to fund the trust, which is this Hegstead petition, or it could be a full probate. Then we get to what are the debts and the taxes and the distribution. And in the end, people don't talk to each other. So I much prefer the former to the latter, because to me, family harmony is what this is all about. Okay, next. Oh wait, there's another poll. I think I might be, oh no, that's sorry. I'm seeing the comments go. Okay, so fatal flaws in trust. When there are successor trustee issues, they're the wrong people, they're 2 or 3 or 4. I've named all my kids as co-trustees. That is a recipe for disaster. When there isn't a successor trustee, we have to go to court. So the funding, when it's incomplete, remember, transferring your assets into your trust is critical. This includes businesses. Not sole proprietors, but if there's an entity, we have to look at all of the assets and get them in there. We can leave up to 184,500 outside of the trust, but we want to make sure all the big ones are in there. If the documents are ambiguous, it makes a mess. Financial elder abuse happens every single day, many times, so we need to make sure the right people have access. If you have a trust that has the mandatory A-B split, this means that you create this family trust as a couple, the first spouse dies, and now the trust, you don't realize this because the lawyer didn't tell you this, and I'm apologizing all the time in these meetings for not getting the proper education from your attorney. The trust has to split in 2 parts. The person who passed away, their share is now irrevocable. The person who's alive, that share is revocable. You can change it, you can do what you want. But splitting the estate in half can be difficult, especially if your main asset is a house that has a mortgage, because the mortgage company does not want you to put 50% into an irrevocable trust. And in their fine, tiny print that lawyers created, I didn't create that, but in that fine, tiny print that none of us want to read, including me, it says we can accelerate your loan if all these different things happen. And one of them could be putting it into an irrevocable trust. So then the trustee, the survivor, is left with violating his or her fiduciary duty as trustee, or not being able to pay off the house and honoring that. So it can get messy. We don't like these A-B splits. They were done a long time ago for tax reasons. The tax laws have changed so much, you don't need to do it anymore. We like trust protectors. Trust protectors is a third-party neutral who will be the judge over your trust, resolves all the issues, and we never need to go to court. So we really like trust protectors. And then I'm a huge animal person, so we need to make sure there's someone in there to take care of your pets. Next. So this, to me, having this updated estate plan is the biggest gift you can give. If you are just, you don't want to do it because you think it sucks. Well, you're right, it does. But if you go to the right attorney, maybe it's not as bad as you thought it was going to be. But the gift that you give to the people you love, your kids, your grandkids, nieces and nephews, dear friends, whoever it is, so that they know how to honor your wishes and they don't have to deal with court and they all get along and love each other in the end. See, I get all emotional when I think about these terrible client situations we have. So just do it. Just, I promise it's not as bad as you think, and you can just start it next week or the week after, or when you get your tax refund. Just get this done so we avoid court. All right, next. Caregiver burnout is real. You will all get this slide. Everyone who is a caregiver, and I have been there, you know that this is true. So get support. You're in the right place to start that. If you haven't gotten it already, Alzheimer's LA is amazing. Next. So 6 immediate actions. You can just do next until we get to all of them. Okay, so create the village and care for yourself. Finish or update your estate plan. Share your wishes with your family, right? Like maybe you have an estate plan, it's not that detailed. Maybe the person who, it's for doesn't have mental capacity anymore to make legal decisions to create these documents, but it doesn't mean you can't talk about what your wishes are. Just think about the scenarios and talk through them. Make sure your assets are organized and you fund the trust and you update beneficiaries and you get logins and passwords and a list of all your bills, when they're due, what account or credit card they get auto paid on, in these when somebody loses capacity or in a trust administration, we end up closing and changing accounts and we don't know what all of these are. And, you wouldn't want if you're incapacitated, your long-term care policy canceling because it didn't get paid. So organize this and put it in a safe place and let the next person in line know where it is. Don't give it out now, but just so they know where it is. And then make sure you're properly insured. I don't sell insurance, but we have the most amazing team of resources, and the person I recommend to everyone to get an insurance audit and make sure you're properly covered. Next. Oh, the myth is, again, everyone, my kids, my spouse, everyone's going to be able to handle this automatically. It is so not the case. Next. So if this is, you've put on your own oxygen mask, but now it's time to care for someone else. And this can be a spouse or a parent. So elder law is really just doing the best you can. Next. And it really is a combination of therapy and helping navigate through this really complicated time, and then having the legal background as well. Next. So when this role reversal happens and we start needing to care for someone else, the caregiver can get, as I've mentioned several times, and I know it's so true, very overwhelmed with the whole legal and medical process. There's sometimes family drama that comes up. I really miss seeing people's faces when I talk about family drama, because you've had it in your family. And if you haven't, you are the anomaly. But when that happens, it can get tricky. And then when the person doesn't have capacity anymore, then it gets, other things come up. When someone's running out of money, that's usually Medi-Cal planning these days. So these are all issues that elder law lawyers deal with. Next. So a sneak peek into long-term care planning. It is, it suffices to say it's just outrageously expensive. So if you need a private caregiver and you want to stay at home, it's between $130,000 and about $240,000 if you pay privately or you go through an agency. If you do pay privately, I'm not an employment lawyer, but as an estate planning lawyer, we got to know a little employment law, a little tax law, a little family law, little real estate law. So you have to follow the laws. You have to pay people through PayPal. You need to have a caregiver agreement. Not through PayPal. Did I say that? Through payroll. Strike that. Through payroll. You can't do it 24 hours. I'm going to give you $200. I have an agreement. You live here for free. None of that. Not only can these people go to the labor board, and if you think that your beloved person whom you've had for 10 years might not go, you're wrong, because it does happen. And not only that, and once you go to the labor board, the employer is screwed no matter what. Even if you've gone through an agency, if the agency isn't doing what he or she, that agency entity should do, the owner, you are still, as the employer, liable. I had someone call me years ago, and I was shocked when I called my employment law friends to find out that that was true. So it's really expensive. But what I was going to say is the Franchise Tax Board is now that they are paid caregivers, and they can tell, and they're notifying so I don't want to say they do a tax audit, but they are notifying the labor board. So it's just so important to do this right. So you can see the different pricing, you know, and the fees for care. Now I want to talk about Medi-Cal. So a lot of people think Medicare pays for long-term care. It does not pay. It pays for, if you are in the hospital for 3 days, it will pay for up to 100 days. If you are making progress. What happens as we get older is something happens, you fall, you break your head, whatever, and then you go into a rehab and you're not making progress, and then they kick you out way sooner or tell you have to pay privately way sooner than you think, and they give you no notice. So if you have a loved one in one of these rehab places, you need to meet with the team every week there to say, I want to know what the progress is. I don't want you to spring it on me and say in 2 days, you know, it's time for me to pay privately or find another place. So you got to stay on top of it. So Medi-Cal, the rules all changed last year. So you now can have, as an applicant, up to $130,000. Used to be $2,000. The spouse can have, non-applicant spouse can have $148,620. So it gives more wiggle room. If it's a couple applicant, you can have total $195,000. And then in 2024, there apparently won't be an asset limit. I don't know if it's going to work. I don't know. You can have millions of dollars, but be on Medi-Cal makes no sense to me yet, but I will learn when the law changes. So first thing, Medi-Cal, quality of care. You need to make sure that wherever your person is going, that you are comfortable with the quality of care before you spend money on a lawyer to do, you know, Medi-Cal planning. That the eligibility part is the part in red above, and then there's share of costs. They are going, if you're in a skilled nursing, they are going to take all of your income except for $35. Now this gets complicated. There are formulas, and the spouse is allowed to have a certain amount because they don't want to impoverish the spouse, but it gets complicated. And then there's recovery. We get calls all the time. I need to create an irrevocable trust so that there's no Medi-Cal recovery. That's not the case. You just need to have a regular revocable trust. But as I talked about, the fund, you have to transfer the assets into the trust, because whatever is subject to probate will be recovered against. Okay, and then sometimes, way back when, we used to do VA planning, but now that they have the 3-year look back, like Medi-Cal, we don't do a lot of VA planning anymore. Next. So if you are caring and helping someone who still has capacity, then these next slides are for you. After that, I'm going to talk about what happens if someone has already lost capacity and some still action items that you can do. Next. I'm going to drink water. Everybody take a quick break, drink some water. If you need to stand up, stretch for a minute. All right. Can you just scroll through all of those as well? All right, thank you. So if you have capacity, get 2 letters of capacity from your doctor. And the reason for this is, 1, it means that you can create your estate planning documents. But 2, for those people who may need a reverse mortgage, listen really carefully, because these laws have changed. I guess they're more like rules of the mortgage industry. So if you want to get a reverse mortgage and you're fine and you're able to do everything, they're not going to ask for anything. But if you are using a power of attorney for someone to get a reverse mortgage, they are going to ask for capacity, 1, sometimes 2 letters of capacity from a doctor at the same time you create, or after you created that power of attorney. And if you don't have that, they're not going to let you get the reverse mortgage. So it's really important. Get those cap decks now. Finish or update your estate plan as always. and discuss this gifting authority with your lawyer about the Medi-Cal planning, which I mentioned earlier. And then of course, get support like you already have with Alzheimer's LA, and they have more resources than you know about. So reach out to them because they're awesome. All right, I have 10 minutes left, so I got to go fast. Next. A lot of people do these do-it-yourself online options. That was the myth part of the prior slide. Just go to a really good lawyer. It's so much better in the end. So if you're unable to make decisions, next. And then just, yep. Okay. So, yep. So if you lose mental capacity, you can't create these documents. You're headed to conservatorship. It's not a fun process. And so that's why if there's any way we can avoid it, we do for our clients. If you can't update your documents, then these are the next 3 things. Next. So what is conservatorship? I think with the Britney Spears, case, everyone knows what it is, but prior to that, very few people did. So if you don't have an advance directive, you don't have a power of attorney, and you've lost mental capacity, you need to go and get a conservatorship. They have conservatorships over the person, which is like the advance directive, and over the money, which is to replace the durable power of attorney. So this judge is deciding who takes care of you, could be the right person or the wrong person, and can take your voting and your driving and your professional licenses away. So we really avoid this, and it's also very expensive. Next. So a lot of people say, oh, I don't need these documents now because I'm fine. Get them once you turn 18. It's a baby estate plan. I don't care if you have no money, get that advance directive and power of attorney. Okay, next. So conservatorship issues, very expensive. It's about $10,000 to start. It is permanent court intervention. You must supply an annual accounting to the court every year. So it's about $4,000 to $5,000 every year with the attorney thereafter for the rest of the person's life. If it's contested by other family members are torn apart, and it's way more than $10,000. So this is obviously a last resort. So do your advance directive and power of attorney today, right after at like 3 or 4 o'clock today. You can go to our website. You can click on the coronavirus part. It will take you. You can do free statutory documents. They're not as detailed, but it's something, and they're legally effective. And then you wouldn't have to worry about conservatorship. Okay, next. This is the PULSE. This is the physician's orders for life-sustaining treatment. Can you click next for 1 second? I don't think I have a blow up. Oh, I do. Okay, perfect. You want to click do not attempt resuscitation if you don't want it. If you want to be resuscitated, you need to pull one of these out and click next. And you're going to decide between selective treatment and comfort-focused treatment. Selective is essentially IV antibiotics. If you want that, you're going to hit selective. If you don't, comfort is really kind of like hospice, even if hospice hasn't been ordered. So it depends on where you are and what you want. Your advance directive, unlike all these other documents where you can't create it for someone else, your advance directive agent can create this PULSE for you. You can change it. So if you want to, you want a selective now, but later you talk to your agent and he or she knows when you would want comfort, you just rip that one up and do a new one. This is signed by the doctor and it is posted on the wall. I hear all the time, I don't want that pink thing posted on the wall. I get it, but don't you want your wishes honored? You don't want to be in the situation where first responders come and they're doing CPR on you and they are breaking your ribs and all of that. It's awful. When you don't want to be resuscitated, you need to have a PULSE. Okay, next. So this is a very complicated slide. In terms of how it works in reality, it is critically important. I'm happy to, do another session at some point just to talk about this. I could go over it with examples for an hour. So really what's important to know is if your assets are in your trust, only the trustee has access and control to them. This means that if the trustee loses capacity, you need to resign that person and it's the next trustee. If, however, the asset is in your name, not in your trust, your power of attorney is the person who handles that. And so for a lot of people, they have the same successor trustee and power of attorney. You're just switching hats. All of your retirement accounts are always in your name. Your power of attorney is managing that for you. But everything else primarily, give or take, can go in your trust and your trustee is managing that for you. So you just want to make sure before you put anyone's name on an account, or add someone to the deed, you are legally giving a gift. A reassessment for property taxes will happen if you put your kid on a deed. Don't do it. I have a client right now who says, oh, well, we're just going to sell dad's house. Dad bought a house in 1974 for $72,000, I think. It's now worth $3.4 million. And they're like, we're going to sell it. You know, the capital gains, I sent an email to our CPA, the capital gains will be over $1 million versus if you wait until the person dies, then you get the step up and there won't be any capital gains when you go to sell it. But property tax reassessment is a whole other ballgame. Prop 19 has messed things up big time. So I know I don't have time to talk about all this, but I have so much information to share with you. Most importantly, don't add people to accounts and just use the power of attorney or put it in the trust and then resign someone. Okay, next. I think, you know, all the legal mumbo jumbo is a big deal and it causes a lot of stress and it wastes a lot of money. But really what's most important is that you spend time together. None of us know how long we're going to have. Tell people you love them. Tell people you appreciate them and make sure you're all on the same page in caring for someone. Next. So this gray area of law, and again, I could spend an hour answering questions on this as well. This gray area of law is what happens if someone has enough capacity to make some decisions, but they're making terrible decisions. So we can't get a conservatorship. And that's really when counseling comes up. So I kind of half-heartedly joke, but it's serious, that I'm a really expensive therapist because I can help navigate this with people, and other great elder law attorneys, I'm sure, do the same thing, where we can talk to the family, we can talk to the, aging person, and we can help kind of navigate through these things to make better decisions and not drive when we shouldn't drive and not give money away when we don't have enough, and lots of other examples. Next. So yeah, the solution is find someone who can help navigate that with you. Next. So find your A team, get an elder law attorney ready, get your end of life expert ready, know what the memorial wishes are for someone, and get all the support and counseling you need. Next. And if I haven't said it enough, because I think I've only said it once, I usually say it way more. Court sucks. Do everything you can to avoid it. Next. So remember, a lot of these plans have fatal flaws. They're supposed to be updated as you change, not just to sit on a shelf in a binder. Remember, if you have any family members who will be beneficiaries or friends who will be beneficiaries and they are on SSI or Medi-Cal, they need a special needs trust, or any inheritance will destroy their benefits. I was really good. I didn't swear, but I usually swear a lot. So if stuff happens, don't wait until it's too late. And it really is easier than you think. And the peace of mind you get is amazing. Next. So study those action item checklists. I do have a favor. My favor is tell everyone, you can hit next, tell everyone you know about this presentation. Send it to people. I don't care if people come to me, go to whomever you trust, but just do it. Don't assume people have this in place. I promise you they don't. And if you have any questions, I'm here to answer them and be a resource. Next. So this is my checklist. When you go to find a lawyer, this is what you should ask. So keep it and ask away. Next. All right, that's it. I'm done.
Awesome. Thank you so much, Rebecca. That was all so helpful as always.
Thank
For
you.
how many times I hear, I always learn something new too.
Oh God, I get so excited to hear that.
Well, we have a lot of questions for you, and let's see, if people haven't submitted questions yet, you can do so in the Q&A. We'll try and get through as many as we can in the next 10 or 12 minutes here, but let's see. The first one is it too late to do an estate plan if you've already been diagnosed with early cognitive disease?
No, and the answer to that changes a little. It's really based on family dynamics. So as long, like if I'm an only child, right? So who am I going to fight with? No one. But if you've got siblings, stuff comes up when you have siblings.
Yeah.
Den has 4 of them, my law partner, so I hear about it all the time. I would say it depends where you are in the process, but you can, as long as you can really make these decisions. And once you get a letter from a doctor saying you have capacity, 100% you can. As this progresses, then not so much.
That makes sense. Okay. Let's see. Next is mom lives in a nursing home. Does having a revocable trust in place avoid probate for her?
Only if the assets are in the trust. So if the assets are in the trust, no probate. If you have a little bit of assets outside of the trust, that's okay. You can have up to 184,500 as long as you have a pour over will. Sometimes we see people, they come to us, they only have a trust, there's no will or missing other documents. So you got to have that pour over will, and then it should avoid probate.
Okay, that makes sense. Can we hire you to create a trust?
If you want.
Let's see. Do we have to go to the same lawyer who made the trust to update the trust if we want to make any changes?
No, definitely not. You can switch, and if you want to tell them, that's nice to tell them. I know that some people will come to us and they feel, a loyalty to their estate planning attorney, and I completely respect and understand that. So one thing I say to help it so that lawyer doesn't get his or her panties in a bunch is just say, I really feel like I need an elder law lawyer now, because we do see things very differently.
Yeah.
And so just like if somebody needed federal tax planning, I would say go to that person, right? So we all have different glasses we look through. So absolutely.
Yeah, no, that makes sense. Let's see. For long-term skilled nursing, does this mean I have to go broke to take care of my wife before we can get help? Someone wants to know.
Well, it depends what broke means. Prior, Medi-Cal planning, as of 2 years ago, I've been doing this 15 years, so longer than that, you could only have $2,000. So that's pretty broke. But now there are, you can have up to 130,000 for the applicant and 148,000 to you, and your house is exempt. If you're taking your RMDs in your retirement accounts, those are exempt. So there's a lot of assets that are exempt. So I wouldn't say you have to go broke anymore, but it is very expensive to have that care. So the state doesn't step in if you have too much.
That makes sense. Thank you. Let's see. Where do I find the statutory documents to avoid conservatorship?
So there's a bunch of different versions online. We, at the beginning of the pandemic, just put the ones on there we trust, and we've tweaked them a little bit to make it a little easier, but still legally valid. So I don't have access to show you, but if you go to goldfarblue.com, in the top middle, it says like coronavirus, click on that and just follow where it takes you. There are sample documents filled out, and you can just print them out. You need 2 independent witnesses for the advance directive. So we made it so you didn't need to get that notarized. It cannot be a person who's going to be your agent. It could be a mail carrier. It could be somebody at the market. It doesn't matter who it is, just 2 independent people. But the power of attorney does need to be notarized. So so those are legally valid. They're not detailed, but they're legally valid.
Awesome. And I kind of along the same lines here, where do I get a POLST form, and does the POLST need to be the pink paper or will white paper work?
Good questions. So the POLST your doctor will have one. We have them too, but your doctor will have them. I suggest it be on the pink piece of paper. You can get it at Staples because that's what first responders and people in the medical community are used to seeing. That's why the creators of the Pulse made it hot pink like that.
Yeah.
So, and you remember it goes on your house and in your house, but then if you go to the hospital, it goes to the hospital. And if you go to a rehab, it goes to the rehab and it's posted on there. And if they tell you it's a HIPAA violation, you call me because that drives me crazy. It's not a HIPAA violation. It needs to be on the wall.
Yeah, no, that makes sense. Good to know. And let's see here. We have a lot of questions coming in. On average, how much does it cost to get an elder law attorney plan where one pays a flat fee for lifelong help?
So I love someone's like flipping these slides around for me. It's awesome. So everybody has different pricing. I don't know of anyone who does the life plan except for us. I was talking to a financial advisor at Wells Fargo who's been doing this for 40 years. And he's like, Rebecca, I've never heard of this. How do you make money? And I'm like, it's not about the money. It's about being a service. So our fees start at $5,900 for a single person and $6,500 for a couple. And that includes putting your real estate or a business in your trust, as well as whatever communication you have, and then we have maintenance meetings we offer every 5 years or sooner if you need them. The only time we charge again is when you want to make updates. Maybe one day we'll come up with like a maintenance plan like that. But for now, that's our life plan. So people email us, they call us, they ask questions all the time and then they don't get a bill for it. So they really like that. And then it makes them actually call us when they have questions and updates.
Yeah, that's great. Let's see. Could you define trust protectors?
So a trust protector is relatively new, a new concept in the last, I would say, 5 to 10 years. It is a third-party neutral, so it will not be a trustee, it will not be a beneficiary, and this person is the person you think is really reasonable, right? Good sound judgment, knows the players if possible, the trustee and the beneficiary. If anything goes wrong in the trust administration, the trustee is doing something he or she shouldn't, the bennies are unhappy with whatever, they can go to the trust protector, and the trust protector's opinion is like a judge. It is the rule. So if the trustee is doing something he or she shouldn't, yank that trustee out, put a new one in, and resolve and be a really good mediator.
Awesome. Thank you. Can you help a family get Medi-Cal for the client? I'm assuming they mean for the person.
For the applicant.
Yeah.
We do that. Yep.
Okay. Let's see. What recourse do we have if the POA is unwilling to release monies for the care of our mom who has severe dementia?
I wish I had an answer. Well, I'm being recorded. I can't say that. We have, and this doesn't help you, I realize, but I want to share this with you so you understand that I get it. We made it in our advance directive that our advance directive agent supersedes the power of attorney. So whatever the advance directive agent says in terms of money and all that has to happen. But I've never seen that anywhere else. So one thing is maybe they get a phone call from a lawyer. I don't know, a letter.
Yeah.
It's not fair. It's not right. It's picking the wrong person for the job, right? So it's hard. I could help if I knew more details, maybe.
Yeah, and for some of these, I know they are a little more specific. So, reaching out directly is always helpful too after the fact.
Yeah, just email.
Yeah. Let's see. Here's one. My parents' trust lists each other as first trustees, and pretty soon my dad with dementia won't be able to make decisions for my mom's well-being. My mom is legally blind and already doesn't make good decisions. Dad does not have an official diagnosis yet. Do I need to hire an attorney to get a third person to come in and help make wise decisions for them?
This is the perfect time to do an estate plan review, to know where these fatal flaws might be, if any, and to know, and now that dad, I forgot I can't ask a question back. If mom has capacity, but is just blind and doesn't make good decisions, we can still update a trust. But when one person loses capacity, most trusts say that now the trust is irrevocable. And we can't make changes, but we still can make changes for dad, right? To say a new power of attorney, a new advance directive, and at least guide and make sure the trust is funded and do the best we can. There are all kinds of provisions in trust, so it's hard for me to tell you what that one says, but getting a review so that you understand all of that and doing what you can is really important to do sooner rather than later.
That makes sense. Thank you. Let's see. My sister and I have POA over my parents. The only asset remaining is their home, which is an irrevocable trust created 8 years ago. What fatal flaws should we prepare for? I'm assuming that's flaws.
And you're sure it was an irrevocable trust created 8 years ago? And I don't know. Some people think it is, but it's not. So if it's irrevocable, chances are you can't change it. Sometimes we still can, but chances are you can't. But if you have capacity, you can still do the advance directive and power of attorney. If you said that was the only asset. So probably there aren't too many, but make sure the advance directive and power of attorney are there, so you at least avoid conservatorship.
Okay.
And make sure the deed says it's in the trust. Right? Just because the trust says it doesn't mean that's the case. Okay, sorry.
No, that's good. Thank you. Let's see, what if someone's only asset is their home? Do they need such a comprehensive living trust?
You mean versus a crappy trust? Just kidding. I would say yes, because it's still your most valuable asset. You still want to make sure that it's done correctly, and so that you don't have to go through probate. So, and remember, it's not just the trust. All these lawyers out there are like, you need a trust, you need a trust. It's your advance directive is the most important document out there. You are asking someone to step in your shoes without any details. It's just not right. So it's the whole ball of wax.
Yeah, well, that makes sense. Let's see, we have just another minute or so here. You can try, I don't miss any. I don't think I asked this one yet. Regarding springing powers, and you recommend giving the advanced care directive out, can you explain that? Are you saying to give a signed copy to the hospital, or who are you giving the documents to?
Good
my
question.
Mom, who has Alzheimer's, and I'm the agent for my parents' trust. I can't make those decisions unless the doctor lets me make the decisions for them.
I probably don't have time to address all of that in the next 30 seconds, but can you just call me? I'll just talk to you on the phone. Just call me. Jessica will make an appointment. Just call me and I'll help you over the phone. How about that?
Good. Well, I think that is all we have time for. So thank you everyone for sending those questions in. And thank you, Rebecca, for taking the time to answer all of those and just for joining us today. As always, we really appreciate having you join us. So
I'm so happy to be here, and thank you all so much for your courage to be here and all your great questions, and have a great rest of your day.
Awesome. Thank you, Rebecca. And again, anyone who would like to have any additional questions or talk with her privately, her information is on the slide there, and it should be shared in the chat too. So thank you, Rebecca, and have a good rest of your day.
Okay, bye.
Bye.